Good morning and welcome to the Senate Committee on Judiciary. I want to thank everyone for being here with us this morning in Carson City and also down in Las Vegas. We have one bill on our agenda for this morning. We have Assembly Bill 291.
Madam Chair, I'd like to make a comment if I could. We have a 34-page amendment on an exceptionally important bill that we literally just got less than an hour before the start of this hearing. I want to protest that. I think we should have an absolute recess on this. We have an opportunity to digest it. I just, it's just really bad protocol to drop that size of an amendment at the last minute like this on us.
And Senator, the one thing that I would note, and what I would note for everyone here today as well, is that the substance of most of what is contained in these amendments has been contained in other bills, including bills that we've heard as part of the hearing on Assembly Bill 291. So I would note that these are
You've heard nothing on the red flag issue at all.
Senator, point of order.
I
would not appreciate being interrupted.
Thank you, Madam Chair. Just want to get that on the record.
What I would note is that there has been this language contained in Senate Bill 120 in a very similar substance that has been available. And so I understand that. We'll obviously give ample time for the committee to answer questions, and we will move from there.
Thank you, Madam Chair. I just want to read it. Thank you.
I am proud to be here today with Everytown, Giffords Law, and Brady United all together at the table in support of AB 291 and the amendment. I'm here because I believe this policy can save lives. This new iteration of my bill.
And so at this point, I think we would move to questions from the committee. So if there are committee members that have questions, Senator Pickard.
Thank you, Madam Chair, and thank you for presenting the amendment. Okay, so Mr. Kowalski, as I'm looking at Section 7I, the acquisition of a firearm within the prior 6 months is an act worthy of removal of firearms. So every owner of a firearm has exhibited a high-risk behavior. That concerns me because it's kind of circular logic in my mind. That's, as I read this, it says they pose an imminent risk of causing personal injury by possessing or having under their control a firearm. So the mere possession is a high-risk behavior? All right, well, that's troubling. Then we don't even have accurate copies. But so let me move on to
Madam Chair, I'm sorry to interrupt because that's a very critical point. We just got this amendment this morning. Is there another amendment?
There is not another amendment. What I would note is that there is an amendment that has been uploaded that should be the amendment that everyone has here in the hearing this morning. And so I don't know if there is some confusion over the section in the amendment that is being discussed currently, but everyone should have the same copy of the amendment.
all right, well, I guess I'm caught at a disadvantage having been given a different version. I don't get that. But anyway, moving on.
I apologize, Sandra Howdigi, for the record. I apologize, Senator. I think I was looking at the wrong section.
Okay. All right, good. That makes me feel a little better because I hope that my study, and you know, the interesting thing is having talked to many stakeholders, I'm going to be very interested to see what particularly the ACLU, for example, I'm going to be very interested to see because I understand they even have trouble with this, but we'll let them speak for themselves. I saw them in the room earlier. So the truth of the matter is this could be an indefinite taking, correct? The short answer, I guess, is they are indefinite until the underlying issue, which is not addressed, which is the mental illness issue. I guess the thing that disturbs me about this is that the law is so written so broadly and the triggering behaviors are so broad that we're going to be terribly over-inclusive. This merely is a way of removing firearms from someone, and my concern is the abuse of this law. This is, in my view, overly inclusive of people that probably don't meet the standard because there is no standard. There's no, the standard is mere possession of a firearm. So Anyway, I'm done. Thank you, Madam Chair.
Other members of the committee that have questions? Senator Hansen.
Surprise, surprise, Madam Chair. Well, again, I'm trying to read through the 34-page amendment as we go here. So the first thing that I want to address, though, if you could, Section 6, line 6, or number 6 on line 32, person who is currently in a dating relationship under this law is going to be allowed to file these types of actions?
This is Andrew Kowalski for the record. Yes, dating relationships, often people in dating relationships are in a unique situation where they have imminent knowledge, extensive knowledge of a person's.
I got it, but that's very, very, very broad. I mean, anybody in a dating, I could see some of the family things perhaps, but to add that into it just sort of shocks me because, and where is the individual's due process rights in this process? I mean, how one person can go, file a complaint with a judge, not have a hearing, and suddenly the cops can show up with this from somebody I'm dating, can show up with an order saying, Mr. Hansen, you're a danger to yourself or society. You have to turn all your firearms. Where's my right to say, wait a minute, I didn't get my day in court? Okay, well, since I haven't got to read the amendment, perhaps you can tell me the point where when one of these are filed and they're turned over to the law enforcement people, and they come to my property and say, we have a court order ordering you to turn over your firearms. I said, wait a minute, the judge hasn't talked to me yet. Is there actually something in this where I am allowed to go before the judge before this is issued?
So it's
simple yes or no?
Yes.
Okay, where?
So you can go before a judge.
Well, where in the bill? I haven't had a chance to read it. You obviously have. You knew this was coming. I didn't. So what section says before this can be enforced, Ira Hansen gets to go before the judge and contest this adverse ruling?
Well, I just want to be clear. There is an ex parte process. But again, that ex parte process is designed only to address situations where there is an imminent threat of violence from a person. That ex parte process can be issued without a hearing. It lasts only 7 days. And then in Section 10 of the bill, the court process is initiated for a full order.
Okay. Ex parte, I'm not a lawyer, I'm a plumber. So tell me what ex parte is, just so everybody can understand as well.
It means without the adverse party.
In other words, I don't have my due process till after the 7-day window is up. Is that correct?
But only upon a finding that there is
Yes or
an
no?
imminent risk. Only upon a finding, sir.
Thank you.
Senator, I would just request that the witness be allowed to answer the question.
I'd love to. I agree. I'm just trying to, since I haven't even had a chance to read it, I'm at a disadvantage because I'm not sure what's in the bill. And that was simply a question. If, in fact, we don't have due process for the 7 days, which is what my understanding was behind this. That's all, Madam Chair. So you're correct. My apologies for talking over the gentleman.
I just think it also would be helpful if you're still trying to read through the bill to have the witness just explain it, because I think he's trying to offer just a bit more of an explanation.
I'm sorry, what was that?
I think he's trying to offer a bit more of an explanation than just simple yes or no.
I got it. I just, because I haven't had a chance to even read the amendment, I just needed to find that out. So thank you.
And so what I keep hearing now, and again, I just got this morning as myself. I'm not a lawyer. I'm going through it. I'm trying to understand it as fast as possible, understanding the dialogue that's going on between you and everybody else who's asking questions. It just seems like we already have that in place right now, that a lot of this stuff can already happen. Then somebody can come in, present an order, guns can be removed. Domestic violence has been there for a long time. It just seems like those definitions have been there, and this is one more. I just don't know why we'd have to go to this next level here.
Additional questions from members of the committee? Senator Hansen.
Question for legal. We're going through the amendment. I've come across NRS 33, NRS 197, NRS 202. What happened to the single subject rule, and are these all considered germane? This is just on the amendment portion of the bill.
Thank you, Madam Chair. Nick Anthony from the Legal Division. Yes, if you look at the title of this bill, it's an act relating to public safety, and everything contained in this bill relates to the single subject relating to firearms. There's nothing in this bill that does not relate to firearms.
Thank you.
I just wanted to clarify, I think earlier there were some questions about contact. And I think we see this language similarly in protective orders involving domestic violence or involving sexual assault. And so ordinarily we are talking about contact, but if I'm understanding this correctly, this is not about a contact with an adverse party would be the violation of an order.
Ms. Xander Karwoski, I'm sorry, can you just clarify that a little bit? Contact with the,
Certainly. So earlier during the course of questioning, I had written down some notes because there were questions about what if there was, invited contact. And I think ordinarily when we talk about protective orders, we are talking about contact between two individuals. But this bill is not contact between two individuals. So there isn't I just wanted to clarify that point of the sort of invited or accidental contact is not something that is covered by this particular protective order.
yeah, this is Andrew Kowalski. Yes, that's a excellent point. I mean, these orders, again, what they're preventing you from doing is having access to firearms. That's the violation of the order. So unlike a domestic violence restraining order, which might restrict you from contacting the other person, these are actually restricting you from having access to firearms. So the way to intentionally violate the order is to have guns.
And I also wanted to clarify, just because I am reading, and I'll reference section 7, which is actually where you can find the walkthrough of what is deemed high-risk behavior, because I think there was a question about whether it would be applicable where someone just acquires a firearm, but under section H, it says, if I'm reading it correctly, that they would both have to acquire a firearm within the immediately preceding 6 months and then also engage in additional behavior, which, as outlined above, would be sort of mostly in the pattern of conduct which presents a danger, conduct which is a serious and imminent threat, pattern of threats or violence, communicates imminent threat of violence, commits an act of violence towards someone, or uses, attempts to use, or threatens to use physical force against another person. So would it have to be both?
Yeah, this is Andrew Kowalski. Yes, so a person would have to both engage in high-risk behavior and meet the evidentiary standard that they're a risk to themselves or others. My understanding, again, is that merely possessing a firearm would not qualify.
Senator Hansen.
Thanks, Madam Chair. Another question for legal. As I read this, if an individual in a household is determined to be a risk, does that mean all of the firearms in the household, including for all the other individuals in the household, have to be removed?
This is Andrew Kowalski. I'm happy to jump in.
I'm sorry, I asked legal. Thank you.
And I guess we can see if Mr. Kowalski, since he's here answering questions, and then if we have a different answer from legal, we can go from there.
Go ahead.
Thank you, Senator. Again, Andrew Kowalski. So any firearms that are in the person's custody or control or possession are eligible to be temporarily removed. There also are strong provisions in this bill that have been deliberately added in to make sure that if a firearm that is owned by someone else is inadvertently swept up in the process, it's swiftly returned to the person.
I got that, but I mean, if I have an individual in a household, from a large family, right? I have 8 children. My wife and I, for whatever reason, somebody determines my son is suicidal. Bad example, probably. But let's say there's something bad like that that's happening. All the firearms would necessarily need to be swept out of the house for at least 7 days to prevent something like that, right? So essentially, everybody else's rights would be compromised under this bill, so that the household basically has to be a gun-free zone?
Xander Kowalski. That's not my understanding. Again, they have to be kept out of the care, custody, possession, or control of the person. So there are other ways to accomplish that than sweeping the household.
Okay, and I'd like to hear what the other ones are. What, lock them in a safe without any sort of them being able to have any access to them? I mean, what I'm getting at is, it appears to me this can be very broadly interpreted in such a way that a lot of people could lose their Second Amendment rights at least in this window of time. And since this window of time could be extended indefinitely by your testimony, it could be very significant for people who are in a household where these sorts of circumstances could occur.
Hi, Madam Chair, members of the committee. Chuck Calloway, for the record, representing the Las Vegas Metropolitan Police Department. We were neutral on the bill originally, but with the amendments, we will be in support. Thank you.
For the record, my name is John Salutis. I am the Vice Chair of the Nevada Gun Safety Coalition. Our mission in Nevada is to advance effective gun safety legislation and policies that save lives and reduce injuries. We are in support of the Extreme Risk Protection Order proposed amendment to AB 291.
Madam Chair, members of the committee, Corey Sulfrino representing the Washington County Sheriff's Office today here in support. We do believe that provisions in AB 291 will help fill a gap and allow us to intervene where we can. Part of the Washington County Sheriff's Office mission is to keep firearms out of the hands of prohibited persons and those with mental health illnesses, and we do hope that 291, while it may not prevent all tragedies, will help us prevent the ones that we can. Thank you for your time, ma'am.
Certainly, Mr. Zolfarino, it looks like we have a question. Senator Hansen.
Thank you, Madam Chair. I'm curious, I just got to see the amendment this morning. What gaps does this specifically fill? What sections in the bill are missing that apparently you had the amendment before we did? So what in there is the gap that you're talking about?
And I would just note, again, Senator, the amendment was posted on Nellis as soon as it was able to be posted, and everyone had it at the same time here in the committee room and on Nellis.
Fair enough, Madam Chair. It's also true that the long gaps and delays in this morning's hearings are because we're all reading it as we speak. So, but I do want to know what the gap is.
Madam Chair, Corey Sulfrino, for the record, through you to Senator Hansen. Senator Hansen, what I was speaking to in reference was in law enforcement in general. We get dispatched to a call. We see that the crime has either been committed or it hasn't, or maybe facts and circumstances don't arise to the fact of a legal 2000 where we can intervene, and we're left there where we can't do anything and something tragically happens later. In these instances now, if we do determine the facts and circumstances don't arise to a legal 2000 and that we have clear and convincing evidence and we can go obtain a search warrant for the firearms to start this process, if you will, and remove the firearms before tragedy occurs, we believe that's the gap that we were referencing, that it allows us to intervene before tragedy strikes.
I was actually the specific section of the bill. That's, I guess you haven't, never mind. Thank you.
Thank you, Majority Leader Canizaro, members of the committee. My name is John Jones, and I'm here on behalf of the Clark County District Attorney's Office in support of AB 291 with the proposed amendment that I have had an opportunity to speak to the sponsor, Assemblywoman Howdeggy, about to Section 26. The language in the proposed amendment came out a little different than it did on the Assembly side in Assemblyman Fumo's AB 153. So we're just asking that those two, the amendment in this bill mirror the amendment that it came out in AB 153. But we are in support of the red flag legislation as well. Thank you.
Good morning. My name is Chip Evans. I'm a co-founder and a volunteer member of the leadership team of Indivisible Northern Nevada. Here today to represent our 1,800 members in voicing support of AB 291 and its proposed amendments.
To opposition, if you're here to testify in opposition in Carson City or down in Las Vegas, please come on up and we will go ahead and start here in Carson City. Mr. Reed, whenever you're ready.
Good morning, Madam Chair. For the record, Dan Reed with National Rifle Association here in opposition to AB 291. Today I'll focus, per your request, on the red flag portions in the mock-up amendment. With the amendment that I have been perusing through this morning, with these laws, it removes your constitutional rights not because of a criminal conviction or a mental adjudication, but based on third-party allegations with evidentiary norms well below what we normally expect when we remove someone's constitutional rights. As you heard some substantial conversation about the group of who can bring these, we see it's kind of a loose-knit definition when it comes to intimate partners or dating relationships. We don't really have clear definitions there on who's actually bringing these, as well as anyone can bring them through law enforcement. This bill, the red flag portion, lacks due process, as these can be done through ex parte orders, meaning you are not required to have notice before you lose your constitutional rights, and you may not have an opportunity to be heard for at least 7 days, or maybe more. And I think there's a section in the bill where it talks about if that I'd like a little bit more clarification on. If the emergency order is filed at the same time as the extended order, whether that hearing actually has to take place within 7 days. And so I think that's something that we should look at a little bit closer. Also, law enforcement can actually do these without even appearing before a judge, but over the phone. So, I mean, our due process protections are very low here, and we're talking about someone coming in without notice to you and taking away your constitutional rights, and you're actually being forced to surrender over your firearms. When these notices come up, I know there is some de-escalation language in here with law enforcement that I'd be curious to hear from them on, but what we have heard in some other states is this is actually escalating situations, because when cops go out to serve these orders, it's not just your neighborhood beat cop that's going to go and knock on your door. What they're hearing is that you're a dangerous person with a firearm, and I've heard from some law enforcement outside of this state that this is a SWAT call for them, and it would be interesting to see what law enforcement and how they're going to treat that here. Also, in regards to the de-escalation language, it says that they could just walk away if the situation is dangerous, and I'm kind of curious how that plays out. I am not in law enforcement, but if there's a dangerous situation, are law enforcement just going to leave them and come back another day? Because I thought the whole point of this is that it was imminent and something was to take place. We've heard about the least restrictive means, or the less restrictive means have been exhausted. I'd like to get a little bit more clarification on what those less restrictive means are. In Nevada law, we do have the Legal 2000 process, and one of the big differences there is there's actually a mental evaluation that takes place. Here, we're saying you're too dangerous to exercise your constitutional rights and continue to possess firearms based on these third-party allegations, but have a nice day. You know, we're not going to account for any other element of dangerousness that this person might possess, and we're not even going to have any follow-up with a mental health professional. We're just going to say, you're too dangerous to exercise this right, and we're going to have a hearing on that in a couple of days, and we might extend it for a year, and we might extend it indefinitely because there's no limit on the number of times that these orders can go forward. One of the things this bill talks about is storage of firearms. It says they can either be stored with law enforcement or they can be stored with an FFL that's contracted for. I'd be curious to know if there's any fees that are associated with that. If someone who's subject to this order, are they going to be charged by law enforcement to store these firearms? Or if they're contracted with an FFL, are there going to be storage fees that FFL is going to be put on, is going to be placing on someone, especially with an unknown date of this order actually dissolving? If they continue to be extended, that could well exceed the cost of the firearms, et cetera. So I think that we need to vet out how that's going to take place. Also, I don't see anything that makes sure that those firearms are stored in good condition, good order, because some people have fairly extensive firearm collections, and some of those firearms are worth lots of money, or they have sentimental heirloom type values. And if those are sitting in a rusty warehouse somewhere and they get them back and they're in damaged condition, that would be really unfortunate for someone who, again, has never been convicted of a crime, never adjudicated mentally ill, just had these firearms taken based on allegations. I'd like a little bit more clarification on the return of the firearms. The language says that they shall be returned not less than 14 days. Does that mean they have up to 14 days to return them, or they can't return them for at least 14 days? And what's that process look like? I know in some of the other states that I've worked in, getting firearms back from law enforcement can be a challenge at times. It can involve the use of counsel, and it can be expensive. And so I'd like a little bit more clarification on the return of the firearms. Also, the appeal process. As I was quickly going through this, it looks like Section 16 and 17 might cover the appeal of this. So if someone brings these allegations against you, there's the low evidentiary standard that goes for and takes away your rights. And now you're saying, hey, wait a minute, this doesn't exist. The way I'm reading this, it doesn't look like you can actually appeal without the person who brought forward the allegations to agree to it. And so I would like some clarification on how that appeal process works. And if you do have an appeal process, what's the evidentiary standard that someone might be met? Are they going to try and prove a negative, that they are actually not dangerous? And how does that actually look in practice? Fiscal, I noticed there are no fiscal notes on this. I realize that the amendment came forward just before the start of this hearing, but obviously there are going to be constraints on DPS for these records with the time frame of putting them in, taking them out, especially if they're going in for maybe only 7 days or 30 days, and they could be responsible for the attorney's fees if the records are in there wrongly. And so are they going to have some sort of protections from lawsuits, since attorney's fees are recoverable, and it's not uncommon for records, especially we've talked about background checks earlier this year with the NIC system, for records to be in there and not to appropriately come out, or someone is getting held up because they share a similar name, a similar birthday, or similar address with someone. And I know that DPS is working hard to address the backlog of the current record system, which I know some monies and positions have been allocated, and I think that's good, and I think there's a piece of legislation dealing with that.
And Mr. Reed, I would just note that we've gone a while, but we'll give you time to sort of wrap up and go from there. Thanks.
Also, just in another jurisdiction, they're actually mandating training for law enforcement. I don't know if that was something that they would be interested in doing, that specifically in California, where this law has been in the books for a couple of years, and they're seeing a gap in them actually being able to appropriately effectuate these in practice. And so that's something to also explore, as well as any response costs. I could go on, but I do realize you're asking me to wrap up, and I appreciate your time and indulging me past the 2 minutes, Madam Chair. Thank you.
Thank you.
Good morning. My name is Darlene Cooley. I'm here to speak on behalf of the Nevada Federation of Republican Women. We're a statewide organization of 16 clubs and over 1,150 members. After celebrating Memorial Day, we are reminded how our brave men and women paid the ultimate sacrifice to protect our freedoms and our constitutional rights. It is ironic that our state legislature is voting on a bill that takes away those very freedoms our military died to protect. Please keep in mind that limiting the effectiveness of guns in the hands of law-abiding citizens does not stop criminals. Citizens with effective guns will help stop criminals, and criminals generally don't follow the laws. The Nevada Federation of Republican Women respectfully asks this committee for a no vote on AB 291. Thank you so much.
Thank you.
Hello, my name is Greg Ross, and I'm here to oppose AB 291. I'm very concerned about the process of enforcing the emergency protective orders, and especially the search warrant process. I believe that it will be used to stifle freedom of expression by gun owners. You'll have to be careful of what you say, lest you be subject to one of these search warrants, which likely will be done with a SWAT team. And if you look at Maryland, in Maryland at 5 a.m., the SWAT teams basically came to a guy's house at 5 a.m. His name is Gary Willis. And they encountered this man, and he was armed with a gun, and they shot him dead. I don't think that this is going to be effective at preventing suicide. It's going to cause confrontations between gun owners and police, where you have a person who might be somewhat mentally disturbed. He might take that opportunity where you have the police at his door, or possibly knocking down his door in the middle of the night, to engage in a confrontation with the police, and might result in the loss of his life, possibly the loss of the lives of the police, where it would be unnecessarily done. And if the warrant was not executed, the person would still be alive. I'm also very concerned about dogs. I'm a dog lover myself, and I feel like this red flag law is one of the first types of laws that makes me question whether I can continue to live in the state if this law passes, because I feel like if I am not careful what I say, I may end up with a SWAT team knocking down my door and shooting my dogs, just because that somebody thinks that I'm a threat to myself or others, and that is not acceptable to me. So I strongly urge you to oppose this bill. Thanks.
Let's go down to Las Vegas, and whoever would like to begin, just hit that microphone button and please identify yourself for the record.
Hello, my name is Matt Henniger. I'm a father, business owner, and voter here in Las Vegas. And I just wanted to express my opposition to AB 291 on the basis that the red flag law lacks due process. If I was to be accused of something by my girlfriend, I really want to have the ability to be able to go in front of a judge and express my point of view. And I feel that the way that the law is written just kind of takes out that due process, and that's my biggest concern about this bill. And my other disappointment about the whole process is the short notice that that was given to people to look over the bill and understand the law. So that's my comments. Thank you.
Thank you. Next in Las Vegas, please.
Hi, my name is Anthony Connolly. I'm here to oppose AB 291. I'm a resident of Las Vegas and I'm a police officer, a local police officer. So if this law does pass, I don't know, but I may be the one to go serve the search warrant. There's been talk about due process with this law, and I think there's a fundamental misunderstanding on what due process is. From what I'm reading in this law, and I only had like 30 minutes before the hearing to review it, there's no mechanism for the adverse party to address a judge his concerns on the order. If there was a mechanism, would there be a way to stay the order against the removal of firearms from his home? There's nothing in the law that I'm seeing that addresses this, and so there is no due process protection. Basically, the applicant can make an accusation to a law enforcement officer like me when I respond to a call for domestic violence, and then I can petition a judge to get a warrant telephonically or something, and then the judge will decide if there's preponderance of the evidence or clear and convincing evidence, depending on which one they want to get, and then they can issue the order that the adverse party has no firearms, and then they have 72 hours on a weekend or one business day during the weekday to comply. I have a lot of concerns with that, and I'm a pretty young guy. A lot of my friends in my police department are young. We have families, and I don't want to get hurt or die trying to enforce a law that is arguably unconstitutional the way it's written right now. So if there was a way to fix the due process mechanism in here, of which there is none, I may be able to support it, but right now in its current configuration, there's absolutely no way that this is constitutional, and the first gun that's taken, they probably would have a good case to appeal on. Thank you.
Thank you. Next down in Las Vegas.
Thank you, Madam Chairwoman. Hi, my name is Jeff Watson. I live in Henderson, and I oppose AB 291. It was mentioned by those who support this bill, that this bill could have prevented the Parkland shooting from happening. I want to bring up, what about all the calls and the leads on the shooter, Nicholas Cruz? There were multiple calls to both Broward and Palm Beach police departments and the FBI, yet nothing was done to prevent this mass casualty from happening. The other things that I want to bring up is what causes an assessment of a threat, and what is the probable cause for this alleged protective order to begin? Who decides that? What about my civil rights? What about my due process? I am presumed guilty, having to prove my innocence with the burden of proof on me, not on the prosecution to prove that I'm guilty. This creates an unfair environment, causing undue personal and financial stress fighting this allegation. It also does nothing to get my reputation back, let alone my firearms. You proposed NICS being able to clear this issue if you were found not guilty. NICS is already understaffed and overburdened dealing with background checks. I can tell you my last firearm purchase in January took over an hour and a half on a Saturday just to even get an answer of confirmation proceed or denied or delayed. Who then guarantees this being removed from the system? Who does the checking to make sure this is removed from NICS system checks and my rights are fully restored upon vindication? Also, storage of firearms should be up to the owner, not you mandating this to be. I don't ask how you store your vehicle, which kills just as many people if not properly used and stored. This bill will do nothing but continue to strip rights away from law-abiding citizens. It takes choice away from those responsible citizens because of actions of a few who are bent on creating havoc and causing mass casualties. Enforce the laws already on the books. Do a better job of community outreach and education, not by mandating laws which will do nothing to stop violence but continue to strip our Second Amendment rights. Thank you. Have a good day.
Thank you. We'll come back up here to Carson City, and then if there's anyone else who wants to testify in opposition today down in Las Vegas, you can fill those 3 seats, and we'll come to you next. Please.
Hello, my name is Jared Rahman. I ask the committee to reconsider the red flag amendment of this bill before passage. This country's history of gun control comes from a mindset of racism. The red flag or extreme risk portion of this bill enables law enforcement to further encroach on the liberty of minorities. We have seen many examples of racist gun laws dating as early as 1640 in Virginia, with a law that explicitly banned black people from owning guns, even if they were not slaves. In fact, on a wide scale, the Second Amendment did not apply to black individuals until well after the war between the states. This red flag law is no different. Today, nominally, minorities have the same Second Amendment rights as everyone else, but exercising that right has carried a burden of paranoia and hinted provocation. Look no further than the death of Philando Castile. This is despite all the achievements made during the civil rights movement in the 1960s. It is blatantly obvious that the Extreme Risk Amendment attacks not only the Second Amendment, but also the Fourth and Fifth Amendments to our Bill of Rights for all Nevada citizens, but even more so for minority groups. Today, we as minorities still face an encroachment of our civil liberties on a day-to-day basis throughout this country. As we speak, an innocent minority is being wrongly harassed by law enforcement somewhere in this country as we speak. This extreme risk bill is nothing but another racist tactic to target minorities by not just law enforcement, but by third-party allegation of a racist individual who gets a rise out of seeing minorities being harassed for unjust reasons. This is a racist and oppressive road paved by what I assume are good intentions, but I ask you to please oppose this bill, particularly with the racist language of extreme risk laws. Thank you very much.
Thank you.
Madam Chairman, members of the committee, my name is Janine Hansen, State President, Nevada Families for Freedom. I agree with those who have stated their opposition to the red flag portions, that these violate due process and our constitutional liberties. I would, however, like to point out on page 26 the repealed portion that this bill carries. It specifically repeals the section of the law that requires all counties and cities to have the same laws. That's on page 26. The purpose of this section is to establish state control over regulation of and the policies concerning firearms. This is in the current law in 244.364. Am I correct that this is being repealed?
Ms. Hanson, no, because of the original bill had that as a repealed section of the law, and now that's no longer being repealed. That's why it appears in purple double strike through.
Okay, so I'm sorry. I'm very glad to hear that, but I have another section I'd like to discuss, and that's the section on mandatory storage. I live in Elko. I don't live in Vegas. Last year, I had 9 grandchildren living with me, ages newborn to age 15. We have a shotgun sitting by our front door. We have all of the children understand the critical nature of having guns and what happens. They have seen, as a result of the use of those guns, dead coyotes, dead critters, dead jackrabbits. They understand what happens when you use a gun. All the children, no matter how little they were familiar with the consequences of using a gun. This is very important if we are going to have guns in our home, but we have those guns for protection. We have had our turkeys killed, our chickens killed. We have had also wild dogs that people leave. I live 10 miles out of Elko. They come and dump them out there. They are a danger to the children and a danger to our livestock and to our goats. We had a goat that was nearly killed by a violent dog. This portion of the bill that requires mandatory storage is not reasonable, because if you teach children and grandchildren, like I did, as I said, I had 9 grandchildren living with me, then you don't have a problem. It's when you have people who are inexperienced and who have not taught their children correctly. If you have a gun in mandatory storage and you have an invader to your home, or you have a threat, you are unable to protect yourself because of the requirement of mandatory storage, essentially, in this bill, or you will be guilty of a misdemeanor. And if this happens. And so I oppose the red flag portions of this bill, but I also oppose the portions that require mandatory storage. If people are going to have guns, they need to be responsible, and they need to teach their family, including little children, of the consequences of firearms. Thank you.
Gentlemen, please.
Madam Chair, for the record, Randy Thompson, representing the Nevada Firearms Coalition. And I am here on behalf of hundreds of thousands of law-abiding Nevada gun owners who are opposed to this bill. We know it's important to de-escalate a heated situation, especially in cases of domestic violence. But taking the person has proven to be much more effective than taking the gun. And I won't go into a lot of the concerns that have been expressed already today, but obviously without more thorough vetting, we can't explore the unintended consequences of this bill. One supporter said that this bill could have prevented October 1, and I just want to call that out as totally false. Stephen Paddock was not on anyone's radar. So I really don't like how people use situations to say that this could have prevented something. Section 12(1)(b) of the bill says a transfer of a gun to a person. If you, instead of taking it to a court or an FFL or law enforcement, you can transfer a gun to a person. And I just want to call that out as I don't know how that's going to work now that we've passed 143 in the background check bill. I think it's a great way for a person to get a gun out of a house, but how is that going to sync with 143? There are other concerns that we have in this bill, specifically the trigger modifications that have yet to be addressed, but primarily because the sponsors refuse to meet with us on all of these issues. And that's really what's frustrating. I asked, Madam Chair, that you not adopt this amendment and that you give us time in the interim to work out language that protects the constitutional rights of those folks who own their guns, as well as give law enforcement the tools they need to protect the innocent. We are more than willing to work with the out-of-state 3 gun control organizations that wrote this bill. We'd like to actually have the opportunity to meet with law enforcement, to meet with ACLU during the interim, and really come out with some language that works for all of us. Thank you, Madam Chair.
Thank you, Ms. Thompson. And I would remind everyone that we are trying to focus the conversation on the amendment for the red flag, but appreciate your comments. Thank you.
And I was referring specifically to red flag amendment.
Just wanted to friendly reminder for everyone. Please go ahead.
Tim Stoffel for the record. I'd like to talk about something a little bit different on this, and that is the whole protocol that this seems to have been occupied. Earlier in this session, we passed a bill through here, AB 143, and this was kind of ramrodded, no puns intended, through the legislature and was passed in about 5 days. It was interesting when I look back at Nellis on this, that they were holding hearings on this bill after it had become law. At least that was the way I was reading it. So it just seems here that we've got another highly irregular situation where we had 3 bills that were declared dead under Standing Rule 14. Suddenly this bill was brought back by finding a way to declare it exempt, and then coming along and tacking all these amendments into one bill. It just seems to me that someone somewhere wants this bill bad. And then when the amendment finally came along, we had, an hour to look at it? These are the kind of tactics I've expected from and seen from the radical animal rights people who did the same thing in Las Vegas a few years back. But in any case, this is highly irregular and it makes me question if passing this bill isn't going to dull the image that we have of our legislature, because apparently somebody wants this bill so bad that they're trying to force it through. There's a lot of other bills that we've heard that would affect lives as well as just this one, and so I am concerned that we're setting the legislature setting a very bad example trying to pass this bill in this manner, and it should have been done differently. I echo the sentiments of all the people that have spoken about the problems with this amendment, and although I think the extreme protective order has some merit if it is done right, because there are cases where it would save lives, some of the problems have been brought up, especially problems of due process and problems dealing with the fact that if you come along and just you're suddenly held at gunpoint with somebody demanding that you hand over your firearms, this kind of thing can make a problem worse than it can make it better. There are certainly better ways to do it. The last person talked about arresting the person rather than taking the guns. Maybe that's a better solution. In any case, when you combine this with how much AB 291 has not been liked, I think this whole thing needs to be scrapped, and we have to look at something that protects people's rights on all sides around. Thank you very much.
Thank you. We will go down to Las Vegas and then come back up here. And if anybody else wants to testify in opposition, they can fill the seat here in Carson City. Down in Las Vegas, whenever you're ready.
My name's Coney Cunningham, a local resident here in Las Vegas, and I actually lost a friend a few years ago to suicide, and I do not irrationally or selfishly blame that firearm. It seems there's a lot of reassurance and explanation to what's in Red Flag, but to me it seems there's an attempt to pull the wool over our eyes with biased reassurance and explanation. Red Flag laws are an outright act of aggression, especially the language that classifies purchasing and possession of a firearm. Does this mean people open carrying are going to start going to jail? The claim is that Red Flag saves lives, but support fails to mention the multiple deaths on the East Coast resulting from the Red Flag, such as the death of Gary Willis, who was shot dead by the state in his own home. We never seem to think twice when the government kills its own people. These are the type of laws that spurred the conflict between the colonies and England. I'm happy to see the preemption repeal. However, I am displeased it was striked at the order of a political action committee and not the overwhelming opposition of the constituents. It's clear this bill is vague, supports lobbyists over the people. I do not support AB291 and its amendments, and I support the motion to table the bill. Thank you.
Thank you. Next down in Las Vegas, please.
Good morning. My name is Mac Miller. I'm representing Mac Miller from Nevada.com, and the more than 3,500 or 3,500 to be specific, Nevada citizens that oppose this bill. Normally, I like to come in with numbers. I do a bit of a Roth Perot kind of deal because I'd rather put more of that fact into the opposition than opinion. However, while I'm doing research in opposition to this red flag amendment to this bill, I accidentally ran across some numbers, and those numbers were that 5,051 people had been killed. And then when I looked closely, I accidentally typed in how many had been killed by gum and not guns. So apparently the National Safety Council found that choking from gum was actually the fourth leading cause of death. That was irony. We're not talking about that. We're actually talking about gun control. Now, in Iraq, we had fatalities totaling 4,887 as of 4/29/2019. And as of 2015, we had some 5,000 people die from choking a gum. I think we need to get our acts together, stop trying to take away the will of the people and the rights of the people. Previously in this session, you voted to pass a law that said that every vote should count, and yet it wasn't every vote of the citizen that wanted to oppose the bill that you ultimately passed. It was completely opposite of what you did. What is extreme? We can't read minds. Must all individuals be certified to make the determination that another is at risk before reporting to law enforcement? Would a person who reports a law-abiding citizen to be acting suspiciously be liable for a lawsuit if it's later determined that they were incorrect or that the person simply reported the law-abiding citizen maliciously? We know this happens. I've had it happen to me. What is suspicious activity or a clear path to dangerous activity? When my daughter comes home after not getting an A on her math test and is irritated, do I report her? Do I report her mother? When my colleague is upset because his request for vacation time is denied and he calls the boss a four-letter word, do I call Metro and have them go to his house, fearing that he might come back and shoot the boss?
And Mr.
When
Miller,
my mother complains that the...
Mr. Miller, we're
Yes.
just right about at the time limit, so if you could wrap up, I appreciate it.
And I will do just that. When my mother complained that the Affordable Care Act raised the price of her prescription medication and was worried on her knees praying to God to resolve that problem, do I call the police? When I hear that my neighbor's arguing and her husband and she yells, "You're a jerk," do I call the police? Finally, I'll close on this, like I closed many times before in opposition and or in support of many bills that were passed or not passed in this legislative session. You all have this information, but I think the public never knows exactly how much you have, and they never know how many people support or oppose these bills or these amendments. Just in these bills and these red flag bills, I pulled 383 pages and printed them out of all those who opposed or supported.
Mr. Miller, I would note that you are well over the time, please.
Thank you very much. I'll close by saying I oppose this red flag amendment, as do 3,580 people who also opposed and only 250 people reported to you that they supported. That's Mac Miller.
Thank you.
And I oppose.
Next, down in Las Vegas, please.
Good morning, Madam Chair, committee members. My name is Trenton Puckett. I'm here representing myself as a constituent, combat veteran, and military retiree, and testifying in opposition to AB 291. While in service, I had the honor of serving as a military police senior non-commissioned officer, so I'm coming at this from a prior law enforcement viewpoint. I note that ERPOs divert law enforcement resources away from their role as first responders and place them in a role in the mental health system, a role for which they are completely untrained for and ill-suited for. They place police officers at risk when they show up at a person's door to take firearms away from somebody they know is mentally ill. We've seen in the past where this has resulted in the deaths of citizens and police officers alike. But the core of this argument is that ERPOs remove a citizen's right to self-defense without due process. We know that a firearm is the most effective tool for an individual to defend themselves. So removing those tools places those who are most at risk, our immigrant communities, those who are religious or ethnic minorities, our LGBT members, and our persons of color and women. These are those who are most in need of self-defense. So again, I urge you to vote against this bill. Thank you.
Thank you. Next, I think we have one more person down in Las Vegas, and then we'll come back up here. Oh, no, sorry. We did go through all three. We'll come back up here to Carson City, please. If there's anyone else down in Las Vegas who is planning on testifying in opposition, you can take those 3 chairs there, and we will come to you next. Please go ahead.
Thank you. Gordon Utes. I'm here representing the 785 members of Stillwater Firearms Association. We oppose this bill based on the grounds that it eliminates due process and the fact that it is open to abuse. And I'd like to close with a question. If this is truly the will of the people, why the secrecy? Why was it that nobody really got a chance to look at this, including the committee members, until immediately before this meeting? Seems to me if it was a good idea, you'd want everybody to know all about it way in advance. Thank you.
Thank you. Please.
Hi, my name's Scott Cooley. I am a constituent in Washoe County, and I am representing myself. And after sitting here and listening to this, I just wrote down a bunch of stuff that piqued my interest. The fact that there's no mental health assessment for this portion of the bill really bothers me. I mean, you know, let's look at the person, not the gun. There's no restrictions for you take the gun away, you send the person home, and then you turn around and say, okay, you've got knives sitting in your kitchen, you got forks, you got tire irons, you got bats, you got shovels, any other number of weapons that you can use to perpetrate whatever crime you're planning on perpetrating. So let's go after the person, not the gun. We have nothing in here that says how much this is going to cost the taxpayers. How much is this going against our current budget? You know, who's going to bear the cost of storing these guns, and who bears the cost of the legal costs and the police costs? Let's see, what else did I have? Oh, you know, one of the supporters talking about someone who unfortunately lost their life in Indiana and was killed by someone who was mentally ill. They had a red flag law there. It didn't work. People are supposed to feel empowered. The people did not feel empowered enough to call on their own family. Maryland has a red flag law. Baltimore is on pace to become the murder capital of the United States. Illinois has a red flag law. Chicago, over this past weekend, 39 people shot, 7 people dead. How'd the red flag laws help there? My only problem with firearms storage is really I don't have children, so you know this is something that shouldn't relate to me ever. But what about my violation of my right to privacy? My home is supposed to be my castle, and now you're going to come in and tell me that you're going to arrest me for doing something in my home that's wrong, that's not wrong to me. That's all I have to say. I'm opposed to this bill, and I hope that you guys will set it aside and wait for another time to come up with a better law. Thank you.
Thank you. Next up here in Carson City, please.
Bill Majora from Washoe County. If public safety is the excuse for AB 291, but it doesn't seem to be the reason. If public safety was the purpose of AB 291, its sponsors would have invited input from gun owners to help focus on public safety instead of surprising everybody except the supporters at the last minute with the flawed language in AB 291. Law-abiding gun owners are guilty until proven innocent under red flag laws, and that bothers me. In Florida, we've talked about school shootings in the course of this hearing, and in Florida, the commission investigating the school shooting in Parkland recommended allowing qualified school employees to be armed. John Lott at the Crime Prevention Research Center has said that he finds no school shootings at schools with armed employees. About mandatory gun storage, in California they passed that, and for years it didn't seem to make any difference in the number of children killed in gun accidents. And nobody seemed to get prosecuted under the law. And it's, in most of the states, the child endangerment laws are adequate to prosecute for child endangering with unsafely stored guns. There was a horror story in California about 20 years ago with the Carpenter family in Mariposa when some lunatic in the neighborhood quit taking his mental health medicine, and he got into the house when the parents were gone in the daytime and the children were home, and the eldest, a 13-year-old, got a hold of their family revolver and couldn't protect her siblings because the revolver had a trigger lock on it. She didn't know how to get it off. The lunatic with a spade fork, a digging implement, killed 2 kids and severely injured a third. Eventually, deputy sheriffs came and killed the lunatic, but 2 kids killed, 1 injured. And about suicides, I heard mention of that also. In Japan, which has practically no privately owned guns, they have, according to the World Almanac,
And we are at the time limit, so if you could wrap up, I'd appreciate it.
they have about the same number per capita of deaths due to murder and suicide as in the United States.
We'll go down to Las Vegas, and whoever would like to begin, thank you. Whoever would like to begin, please go ahead and identify yourself. And if there's anyone else here in Carson City who would like to testify in opposition, please, you can come and take this chair. Down in Las Vegas.
Good morning, Greg Quintana from Henderson, Nevada. I'm glad that somebody mentioned the name Gary J. Willis from Maryland, 61 years old, who was murdered because of the red flag laws. So these red flag laws are causing chaos. They're leaving blood on the streets. And these people who support this bill want to bring that to this state. I'm also glad that there was somebody up in Carson City who posed a very interesting question. He asked, he basically made a statement that it's interesting that somebody really wants to get this bill passed. Well, I know who that person is. I think we all know who it is. It's Michael Bloomberg, a billionaire tyrant from New York City who has spent lots of money to get all these anti-gun bills passed. Most of these people sitting behind me in the red shirts, they're funded by Michael Bloomberg. I'm not a lawyer. I didn't read the bill or anything, but I do have access to Google, and I can cite you some clear facts. These are facts that are public knowledge as far as where Michael Bloomberg is spending his money. Aussie Fumo, $10,000. A bunch of people spoke earlier today about Aussie Fumo's section of this bill regarding gun safety. Well, there you go.
and sir-
Aussie Fumo, $10,000.
And sir, I would just ask, I did mention this earlier, that we are focused on just the amended portion of the bill and the objections
Correct.
to
But
the actual bill.
These folks back here spoke about that safety portion as well. They spoke a whole lot about Aussie Fumo, and I just wanted to let everyone know that Aussie Fumo is bought and paid for by Michael Bloomberg. Linda Cavazos, who also spoke here earlier, $1,000 from Michael Bloomberg. You, Nicole Canizaro, chairwoman, $10,000 from Michael Bloomberg. You are bought and paid by Michael Bloomberg. How about that? And lastly, I'd like to mention, since most of you Bloomies, the Bloomberg people here, like to cite surveys and studies and polls stating that a majority of Americans support these bills, well, I would direct your attention to your own legislative website that has an opinion page, and look at what AB 291 is calling as far as numbers.
And sir,
239
we're right about
in
2 minutes, so
support.
if you could just finish up your thought.
2,997
Sir,
against.
if you could finish up your thought, we'd appreciate it. Thanks.
You're afraid of facts, aren't you? Okay, so I'm done. I just pointed out 2,997 against this bill. Take a look at that. There's your poll right there. Have a good night.
Next down in Las Vegas, please.
My name is Patty Jezanoski. I just have to shake my head with this amendment. I wasn't able to review it, and that's what you want to talk about, because I don't have a copy of it. I looked where this bill was at 4 o'clock in the morning on Tuesday morning, and on Nellis, it still said that it had failed to meet the May 17, 2019 deadline. It didn't say anything about it being exempted. I found out late yesterday afternoon that it was, but there was no new amendment posted. This amendment seems to be presented by the man from Everytown for Gun Safety. Are they the ones that wrote this? Why weren't the questions answered by the legislative lawyer instead of him, where the man is saying, I think, well, maybe. So if a cop or a sheriff is a roommate to the person that is having his or her gun seized, so that cop will not be able to perform his job for 7 days because his guns will be removed. How does this address the person who illegally owns guns? If he has them at multiple locations, or if they claim they belong to someone else and that person doesn't reside in the home. Suicide, removing firearms. Will you remove the knives, pills, cars from homes? Since I know suicide, I know of secondary suicide means after firearms were removed. In this state, as a medical professional, maybe the reason for suicide in this state is higher is because Nevada has some of the worst medical health care since I came here in 2000 from Minnesota. I suggest that all of you supporting this bill turn your cars over, because someday it might kill someone. Thank you.
Next down in Las Vegas, please.
Hello, my name is Daphne Lee. I'm a lifetime Nevadan, a mother, and a law-abiding gun owner. And I, too, echo the sentiments that, coming from a family with military and law enforcement, I was really shocked that after we just all celebrated Memorial Day, that these kind of tactics would be employed to sneak in at the last minute this kind of egregious language in a bill like this. And I haven't had the chance to read it like many of the legislators and everyone else has said, because we haven't seen it. Anyways, I echo all the sentiments that everyone had. Baltimore Police Department is in a big scandal right now for having drop guns being used after they shoot citizens. The guy in Maryland, yes, that was a tragedy that deeply concerned me about these kind of bills. What does that due process look like? I mean, we're having SWAT ascend on people's homes. Are they bringing dogs? Are they tearing up your house? Are they going through your closets? Are they breaking open your walls? I mean, I don't even know logistically how this would work. So if my son is accused by some young girl who's mad at him because she broke up with him, then my firearm's going to be I'm going to be traumatized by SWAT, coming down on my house. Nobody talked about, we have in place psych holds. Yeah, I agree with everyone else. I have 2 friends that committed suicide recently too, and this wouldn't have done anything for that. We need to be focusing on the person's mental health. Just taking away one tool that's protected by the Constitution is not enough. And I kept hearing people say other states are doing this, other states are doing this. Other states were also supporting Jim Crow laws at one point in time. It's unconstitutional. This law is completely egregious to the Second Amendment. And just because other states are doing it doesn't make it right. Thank you so much for your time. I appreciate it.
Thank you. We will come back up here in Carson City. Whoever would like to begin, please.
Thank you, Madam Chair. My name is Jim Hindle, and I'm the Vice Chair of the Nevada Republican Rural Caucus and Chair of the Story County Republican Central Committee. I'm here this morning speaking on behalf of the Nevada Republican Party. The Nevada Republican Party opposes AB 291 and the adoption of this amendment. It appears that this bill and this amendment is about restricting gun possession and ownership, not about preventing violence by mentally unstable individuals. We support the minority party senators here today in protest of the late and last-minute nature of the presentation of this amendment in terms of the appropriate preparation for this hearing, as well as the time left in this current session for careful consideration of this bill and its amendment by the legislature. I personally referenced Nellis last evening to investigate what bills would be heard in this hearing, and AB 291 was not even listed, let alone noticed as the focus of the proposed agenda. We've heard from committee members that they have only today had the opportunity to review the pending amendment. In light of these statements, it is curious to us that over 24 hours ago, the Nevada Independent published an article discussing in detail how this bill would be amended in hearing today. It is distressing when the public or when the press seems to have more notice and information than our legislators or the public, especially on an issue as impactful as the one we discuss here today. Specifically to the amendment you consider this morning, it seems clear to us that this isn't about reducing violence, but about restricting gun rights. If this is not so, then why the focus on firearms as the only weapon of concern? What about other weapons? To justify the mix of topics in this bill, it was even said today that the bill is appropriate as the single focus is firearms. Hence, it seems the intent is not about preventing violence by mentally ill, violent, and aggressive individuals, but on restricting firearms ownership. I don't doubt the good intent of the individuals proposing this bill, but the language of this bill is poorly crafted. If made law, this bill will not keep mentally ill people from committing criminal violence. The words and potential interpretation of this bill are full of unintended consequences. Intent, poorly implemented, does not achieve desired results. Please oppose this amendment and the whole of AB 291 so it can be more effectively crafted and vetted through a more appropriate bipartisan deliberative legislative process. Thank you.
Please, next.
Good morning, Madam Chair. Sean Meehan for Guard the Constitution. I wanted to echo what Mr. Hindle said there. At 1:50 p.m. yesterday, the Nevada Independent published an article that had to have been written no later than noon, where there is a quote, Howdigi said she was pleased with the amended version of the bill. This amendment obviously existed yesterday around lunchtime, and our representatives, our elected representatives, have indicated on the dais that they just saw it this morning. That's troubling. I want to thank our Republican women's representative that cited Memorial Day as a veteran that touched me on Monday, where 1.4 million veterans have died in the history of our country to defend our Constitution, specifically our civil rights. It's ironic that we're talking about due process today. I want to thank Mr. Reed, the attorney from the NRA. He very well articulated the problems with due process. An earlier representative, I believe he was from the Gifford Center, cited the mass shooting at the University of California, Santa Barbara. Being from Santa Barbara originally, I followed this very closely, and I wonder if he noticed the fact that law enforcement visited this individual numerous exhaustive times, failed to check the gun database that under California law is registered. They should have known this individual had firearms. God bless the law enforcement. They admitted they made an error. But this individual, as Mr. Pickard highlighted, should have had mental issues addressed. The 5th and 14th Amendments to our Constitution both articulate due process. Saying that you protect due process is different than actually protecting due process. Thank you, Madam Chair.
Thank you. Please.
Madam Chair, for the record, my name is Melissa Clement. I'm here today representing myself, and I am opposing AB 291. My husband and I are Reno residents and own a small business dealing with concealed weapons permit classes and general firearms training. My husband is a retired police officer and specializes in providing small group-sized training geared specifically to women. He has a heart for this because he was raised by a single mother who so often felt endangered. Throughout his law enforcement career, he felt powerless when responding to sexual assaults, robberies, and domestic violence calls where women were victims because he arrived too late. He works every day to change that now. I challenge all of you on this committee to change your perceptions. When considering this bill, most people will think about the abusive or mentally ill man. I would ask you to instead consider the growing number of women who are concealed weapon permits owners, the fastest growing demographic, at 111% growth between 2012 and 2018. That's women. Now, why are they doing that? Because firearms are the great equalizer when it comes to enabling women to protect themselves against abusive boyfriends, husbands, and other bad guys. With a lack of due process in relation to the red flag portion of this bill, one call can endanger women. This is a woman's safety issue. It is not an exaggeration to say that women are literally dying every day at the hands of abusive men. Stats indicate that about 3 women a day are being killed by abusive partners. Helping women to protect themselves can save lives. One call, though, one call can take away her ability to protect herself for 7 days. Because an abusive boyfriend, an abusive husband, can make that call just like everybody else can. Law enforcement response to the scene of an attack requires time. Abusers are usually not still present when the police arrive. Police, even if they put resources toward the arrest of an abuser, might take several days or weeks to locate and arrest the abuser. And there's not enough jail space to keep them confined beyond 24 to 48 hours. And if she is under an ERPO, she's completely defenseless. I can go through a bunch of examples, like the college track star who warned police about her ex-boyfriend 6 times in the 10 days before he killed her. There are numerous accounts like this. This is a rushed bill, like so many this session. I have to say it's probably the most frustrating thing that I have dealt with this session. So many times I have heard legislators say, well, that's not what we intend, but all too often that is what the words say. I encourage you, take a breath. Consider the constitutional rights of women, like me, to protect myself. There are countless people who wish they could be here today, but with the notice given, sadly they can't. Many of them think, after this session, why bother? You won't listen.
And I would just note that we're right about the time, if you could wrap up, please.
They have emailed, they've called, they have shown up to meetings and testified, they've registered their opinions on the legislative website. Overwhelmingly, on so many issues, the people have been ignored. I urge you to vote against AB 291 in its entirety.
All right, we'll go down to Las Vegas, whoever would like to begin, please.
Good morning, Madam Chairwoman and members of the Senate Judiciary Committee. My name is Linda Cannon, and I'm here today on behalf of Nevadans Can, a grassroots advocacy organization. I'm not going to belabor a lot of the points that have been already made about this bill and how damaging it can be. My thoughts from the very beginning are that it's just unconstitutional. It violates the rights that were given to all of us by the Constitution, and it can be taken away, or these rights can be violated or taken away from us simply by the opinion of another citizen. I see so much opportunity for exploiting this bill by angry partners, angry boyfriends, girlfriends. This bill was written way too loosely for it to really protect the rights of individuals. It's too broadly based, and violating those rights will not change the fact that we're going to have violence with guns. But gun control has not ever been able to prevent violence. And I point out to you, as has been pointed out before, Chicago has some of the strictest gun laws in the country and the highest gun violence in the entire country. Criminals don't abide by laws. The Red Flag Bill is another step toward a gun grab, and I ask you to protect our constitutional rights to gun ownership and vote no on AB 291. Thank you.
All right, thank you. Next in Las Vegas, please.
Good morning, committee members. My name is Julie Harford. I'm a co-founder of the Nevadans Can, with a network of over 70,000 Nevadans caring, concerned citizens. I do not want to take any more time to reiterate all the fine points all the other groups have stated. I wanted to summarize the difference. All the groups that have opposed this bill are from the local state, and all the group that for this are out of state. And so we're here wanted to remind you that who do you represent? Do you represent Nevadans? Or are you representing the out-of-state special interest? When they are over 3,000 people took time to either testify or write you to oppose this bill, when only less than 300 are for it. So how would you vote? And also, I like to take this opportunity to remind you, you have taken the oath, saying, I do so solemnly swear that I will support, protect, and defend the Constitution and government of the United States and the Constitution and government of the state, Nevada, against all enemies, whether domestic or foreign. So I don't want to finish the whole pledge, that oath that you took. I just wanted to remind you, I want to first thank you for your service, but also remind you your roles and responsibility is here to protect Nevadans, not the out-of-state people. Thank you very much.
Thank you. Go next in Las Vegas, please.
Hi, y'all. My name is Leo Aguilar. I'm a disabled veteran, Native American resident here in Nevada. Well, first, I was kind of distraught that, no one actually had time to read this. And actually, in class, in school, we actually did an article on the Atlantic, which was Mistrust in Government. And that was basically an opinion poll based on millennials that stated that millennials have over an 80% mistrust in government. The main reason? Transparency. I guess you say that this is part of that, us not being able to see what is actually happening in our local government, especially since it's our local government, not our federal government, which we should have a little more power and say over. Next, I want to say that a lot of people keep saying, oh, we could have prevented this guy from shooting this guy shooting this guy, or a father was carrying a gun and decided to shoot his family. Well, here in Nevada, we have NRS 202.320, which is basically criminal law which relates to the rude, threatening, the brandishing of a firearm in a rude, threatening, or angry manner. This also prevents due process when the ability to face your accuser, not having that ability to do that is kind of cumbersome to the individual. I also wanted to go over that actual incident that happened. It was in Oregon, in the Oregon News, and it was a red flag law that basically a kid was at school. He fit the actual part of everything that falls into red flag, but it's not because he was actually violent or anything like that. It's because he wore a trench coat, kind of met the meat of, dusty, greasy hair and everything like that. Kind of like when you think of, can't remember now, but he met all that criteria, and so the father decided to cooperate with law enforcement. He gave his firearms away. He has never gotten them back, and he's still fighting for it to this day. And part of that is his family, his son, are under constant despair because they have to, well, his son's under constant watch because they say he's a danger when he's not. And it's kind of making their family look bad. And with that, I pray for the police. Oh, actually, yeah, I got one more. Part of this too is that if this was actually enacted, there would have, well, back in 2014, if this was enacted back then, there would have been no Bunkerville incident. See, if that had happened, police would have been able to stop those patriots from actually standing up to the feds. And, that's why we have the Second Amendment, is to stand up against tyrannical government. I'm not saying you are, but, yeah, and with that, I pray for the police who actually have to come to the doors and meet those people who say they have to give up the guns. That's all. I oppose. Thank you.
Thank you. Anyone else here in Carson City wishing to testify in opposition? Anyone else down in Las Vegas wishing to testify in opposition? Okay, I don't see anyone wishing to testify in neutral, either here in Carson City or down in Las Vegas. It looks like we've got folks here in Carson City, so whenever you'd like to begin.
Good morning, Madam Chair, members of the committee. I'm Eric Spratley. I'm the Executive Director of the Nevada Sheriffs and Chiefs Association. I signed in opposed to this bill based on the information which was available this morning. With your consideration of the amendment before you today, we will be neutral on the bill with this amendment.
Ms. Walborn.
Good morning, Madam Chair, members of the committee. It was not my intention to testify today, but I do understand that Senator Pickard had some questions about our position on this legislation. So I wanted to come and get on the record sort of the genesis of where we ended up sort of in a neutral position. Our position of neutrality does not come from a lack of concerns with the aspect of these sort of temporary protection orders in general. That's sort of where the basis of our opposition comes when we're talking about crafting legislation that will punish what we view as punish people before they commit criminal acts. When it comes to red flag laws across the country, we've weighed in a number of ways. Really, the bill that we think is the most effective and provides the most protections when we're talking about taking a constitutional right away from someone is legislation coming out of Vermont. I think the other important aspect of the Vermont legislation is that Vermont also has heightened gun protections like the state of Nevada. Their constitution is very similar to, their constitutional language for gun rights is very similar to Nevada gun rights. But through some negotiations and speaking with the proponents of this bill, there were several concessions that were made. There was very good faith negotiating with us when we were discussing some of the more problematic aspects of it. In particular, one of the original iteration of another version of this bill provided for a look-back period of up to a year when a person, to show that a person exhibits a pattern of threatening behavior. We had a lot of concerns with that because, how far do we go back? Is this behavior that happened, 6 months ago, 2 months ago? How does that threatening? We think that the language needs to be more contemporaneous with the filing of the application, whatever threats might be occurring. And that was a concession, a major concession that was made in this language. There's no longer, in my reading of this, a look back period, which is something where we were able to come to more of a neutral place. But we do largely agree that, when we're talking about protection orders, We need to ensure that there is stronger due process consideration, that contemporaneousness is so important when we're talking about taking people's rights away and taking away their property. So with that, if there are any further questions, I'm happy to answer.
Senator Pickard.
Thank you, Madam Chair, and thank you for coming up and explaining that. I think it's safe to say everybody here on all sides wants to make sure that we address the needs of those that are mentally ill, that are struggling with suicidal or homicidal ideation, and that we need methods built into the law to make sure that we protect them and others. I appreciate your comments on the due process part. I'm curious though, you didn't mention anything about Section 17. It's on page 10, where we're talking about you've got a court that issues an ex parte or extended order and then requires that information be transmitted to the central repository. It's the Nevada Records of Criminal History. The Central Repository for Nevada Records of Criminal History. They're required then to put that in the system, and that's the basis for the background checks. And then in order, under sub 2, in order for that record to be removed from the system, even if an extended order is denied, it requires an adversarial petition. They have to go to court. And then if it's denied, I'm looking down at sub 8, if it's denied even on technical grounds, there's no distinction, so maybe they didn't file the petition properly. They are required to wait 2 years before they can even request it again. That seems to be an arbitrary number. What's ACLU's position on that kind of denial?
For the record, Holly Welborn, Policy Director for the ACLU of Nevada. I mean, again, we're testifying from a neutral place. I think what we would have liked to see, again, I keep referencing the Vermont legislation. I think that under that bill, it was a 6-month period that they had to come back and reapply. We thought that was a better protection. But, you know, through the negotiations, this is where the bill landed.
Thank you, Madam Chair.
Senator Hammond.
Thank you, Madam Chair. Ms. Wilborn, I was just curious, during your testimony, you mentioned that you had good faith negotiations. I didn't know if those good faith negotiations happened with the original bill or the bill that removed the language, the preemption language, or if it was in regards to this amendment. I don't know when, and I guess my point is, when did those negotiations happen, and did it happen with this particular amendment?
Holly Welborn, Policy Director for the ACLU of Nevada. The red flag was more general. I think we were looking back to, I believe it's SB 120. SB 120. We had conversations very early on with Senator Ratty, that was the proponent of that bill, back in February. And actually, in fact, Senator Ratty approached me well into the interim and some of the proponents on it to see what the ACLU stance was on the bill, on that particular bill. And then once there were some conversations about this amended language, I mean, we didn't see this final mock-up until like 24 hours ago, or about 24 hours ago, maybe less. But we had been negotiating on language, you know, based on 120 is my understanding.
Thank you.
And Ms. Welborn, I believe, if I'm remembering correctly, there was also a bill for this last session as well that was heard both in the Senate and in the Assembly Committee. And I know, I think there were folks that were also involved in those negotiations. I know you mentioned during the interim, but I think there was my understanding is that stemmed from the bill from last session as well that had similar language.
That is correct. Thank you for refreshing my recollection. Thank you.
Okay, thank you. Anyone else wishing to testify in neutral on Assembly Bill 291? Okay. We do still have the Assemblywoman if she wanted to give any last remarks on the bill.
I do. Thank you, Madam Chair and members of the committee. I want to thank you for taking the time this morning to hear the amendment to Assembly Bill 291. You heard witnesses say that this wouldn't have prevented 1 October. Well, as someone who was there and had to flee for her life, I say shame on you for presuming to know what the shooter's family or law enforcement knew. Because as reported by NBC News on October 6, 2017, just 5 days after the deadliest shooting in our history, they reported that the girlfriend, Mary Lou Danley, said he was experiencing strange and odd behavior, including laying in bed every morning and moaning loudly, experiencing other strange behavior like paranoia and constantly looking out the windows, as was reported by the Review Journal, all which was believed to be distress and signs of mental health disorder. Extreme risk protection orders are a powerful tool to prevent gun violence. Between 2013 and 2017, nearly 2,300 Nevadans were shot and killed with a firearm. According to the CDC, 53% of all suicide deaths were carried out with a gun, killing nearly 1,600 Nevadans. Members, I urge you to support this bill that will help give family and law enforcement the tools they need to help make Nevada a safer place. I couldn't be more proud to have my name on this piece of legislation that will save lives. Thank you.
Thank you. Okay, at this time, we will go ahead and close the hearing on Assembly Bill 291, and we will open it up for any public comment at this time on anything other than what we've been talking about today. Okay. And we are going to be in recess at the call of the chair for a bit. Oh, we have public comment down in Las Vegas? Sorry, we'll come back in.
Yes.
Okay, please.
Patty Jezanowski. I would just like to ask, since many of us citizens like to be involved with these legislative sessions, that you could give us a better notice as to when you're bringing bills out of the dead file, and what the rest of the week is going to look like, so we can prepare to be here and to have testimony. Thank you.
Thank you. Is there someone else down there wishing to give public comment? Please, go ahead.
Hello, it's me again, Greg Quintana from Henderson. Just one quick note. Sandra Jaragui, $10,000 from Michael Bloomberg. Just thought you all should know that. Bought and paid for. Sandra Jaragui, bought and paid for.
All right, that will close out public comment. We will be in recess.